All right, the number seems to have stopped going up, so I think it's probably safe to get started now. All right, so welcome everybody. Welcome to a webinar that is about a not very fun topic. For anyone who is going through this right now, we hope that you'll find today's presentation helpful. And for anybody who is not going through divorce right now, which hopefully is more of you, I hope that you're able to learn from our presentation and pass on some useful information. So the idea for today's presentation came from a coffee meeting that Margot and I had a couple months ago. And Margot, as you'll see, spends a lot of time working with and helping in divorcing individuals. And I, as an estate and trust attorney, have worked with some clients on the other side of divorce and seen some issues pop up. And I've also seen some executed marital settlement agreements gone wrong. So we thought that by teaming up, we would be able to combine our knowledge into a comprehensive program about sort of the other side of things when going through divorce. And when I say the other side of things, I mean the main side being dealing with the actual divorce procedure and the family law attorney. So what are we planning to talk about today? We are going to talk about how divorce impacts the estate plan throughout the process. We're also going to talk about financial considerations throughout the divorce process. We're going to give some examples of things that have gone wrong and some tips for avoiding pitfalls. Mainly, though, what we really want to highlight is the importance of having a team of advisors that's knowledgeable. Throughout our presentation, we are welcoming questions. If anybody has any, you can, I think you can type into the Q&A box, and we will try to keep an eye on that and answer things as they come up. But we also wanted to offer, after our webinar, if anybody has questions that they wanted to ask us, we will stick around for a couple minutes, and we are also sharing our contact information. So if something comes up that you don't want to share with everybody, you're welcome to reach out to us after the presentation. So without further ado, we're going to introduce ourselves and get started. I'm Leanne Broyles. I am an estate and trust attorney at the firm Frost Law in Annapolis, Maryland. I'm licensed in Maryland and DC. As a firm, though, we are able to serve estate planning clients in Virginia and Florida as well. We work with clients and business owners with a variety of different networks and complex issues to plan and organize their affairs. We also help families dealing with the loss of a loved one in administering trusts and estates. I've been with Frost Law for about 9 years now, and we are a bigger firm, and though my practice is exclusively on estates and trust and tax issues related to those, we do offer a wide variety of services in tax controversy, tax planning, bankruptcy, litigation, and business law. And with that, I'm going to hand over to Margot and John to introduce themselves as my co-presenters.
Good afternoon, everyone. I'm John. I am General Counsel at Rothschild Capital Partners, which is an investment management, wealth planning, and engagement planning firm. Margot and I work together. Margot is the president of wealth and engagement planning at Rothschild Capital Partners, and she'll introduce herself in a second. An important fact about me is that prior to entering the financial world, I was a family law attorney. So I have experience in divorce, custody, and domestic violence matters, and I've taken that forward into the divorce wealth planning world, where Margot and I work together to help people through their divorce, with particular attention to their finances, and then work on launching them into their next chapter, which we'll talk about a little bit today. Margot?
Thank you, John. So as John mentioned, we are an investment management, financial planning, and engagement planning firm. And I specialize in financial advising, specifically as a CFP and what's called a certified divorce financial analyst. We work in support of individuals who are going through a divorce or navigating their life post-divorce, helping them understand and manage all of the financial complexities associated with that. So today, we're each going to bring our own vantage points on how the team can participate together in support of a client.
Some disclaimers and disclosures to get us started. These are required. I just want to mention a couple of things. While we have lawyers on this call, we are not providing legal advice today. This is an instruction seminar. We're also not CPAs, so we're not providing any accounting advice today. So just to get us started, if you reach the point where it appears you're headed toward a divorce, the most important step for you to take is to make sure you have the right team in place, as Leanne mentioned. And this is a key aspect of the entire process in our view. And when I talk about a team, I'm referring to your friends, your confidants, which may be colleagues, attorneys, financial experts, therapists. These people are going to help guide you to a reasonable resolution to this difficult chapter in your life.
Thank you, John. So as John mentioned, we believe that modern divorce requires a team. And just very quickly from the vantage point of the financial professionals, we want to talk about a few key things here. So as part of your divorce process, there's going to be an agreement. And part of that agreement does have financial components and complexities. So don't be afraid to lean on supporting advisors who can work alongside your attorney to ensure that all of those considerations are being made and that you're completely informed and empowered to be able to articulate what you desire and need. The second thing a financial professional can do for you is that mediation and litigation support. So they can make sure that as you're considering specific proposals, that you have the opportunity to actually envision what those future states can look like from a financial perspective in real time. And then something we're going to address in detail today is your post-divorce to-do list. So there are things that are going to be necessary for you to complete financially post-divorce. And so having the right professionals to help you during that time when you may be feeling weary and perhaps need a little bit more support at that moment is critically important. And just to further drive that point home, you know, the purpose of a financial professional in your divorce process is to help you understand your financial picture, think about the future components that may impact you from a financial perspective, and then empower you to make decisions. Just a reminder that your divorce attorney is always the one in charge of your divorce process, and that attorney can lean on other professionals depending on your personal circumstance.
So this is an important aspect to understand when you get to the point of starting your divorce process. All attorneys have different strengths and weaknesses. And as a former family law attorney myself, I can think of a number of both strengths and weaknesses that I had in the process, but it was important to recognize what those were. And when I needed to phone a friend, as I have in this slide here, to find out a little bit more about different topics that require specific areas of expertise. The most important thing, though, when you're looking for an attorney at the start of the process is finding someone you're a personality fit with. So you may, in fact, want an aggressive divorce attorney, but that person may not be a personality fit with you, and you need to find someone you jive with because you're going to be talking with them all the time, and you really need to trust them. But there are a number of ways that you can kind of get some answers to important questions at the start of the process. And usually that happens during your initial consultation with the attorney. You may hold a number of initial consultations with several attorneys just to see who you fit the best with. But there's some questions here that I just wanted to put forward that you might consider asking during an initial consultation. Does your lawyer understand the complexities of estate planning and trust? If you have complex trusts associated with your asset base, do they understand irrevocable trust, revocable trust, Q-tip trust, spousal lifetime access trust, to name a few? We'll get into some of these a little bit later and talk about what they are. Will your lawyer flag some of the more advanced financial concepts in a settlement? So, for example, there are nuances with respect to retirement accounts. There are challenges with capital gains and capital losses. So if you sell a stock and incur a loss, that may be a tax advantage for you, and it could appear in a tax return for you in your joint tax return with your spouse that you have $100,000 in capital loss carry forwards. If that's there, does your attorney know how to handle that in the divorce? Future cash receipts, for example, a tax refund. How does your lawyer handle that in terms of the division of marital property? If there's a large tax refund, for example, expected in the year following your divorce, do they pay close attention to that in the discussions? If you have any question about your lawyer's depth of knowledge You can request that they take a team approach. Obviously, it's up to that lawyer as to whether they're comfortable with that, but they can call up an estate planning attorney, a financial professional. They can even leverage the help of a therapist in circumstances where there are complex emotional needs in cases, which can come up, obviously. So just remember, it's important to feel comfortable with the attorney's personality, but also make sure you're comfortable with the extent of their knowledge in the case. And divorce is about more than just the legal end of your marriage. It has estate planning complications. So from here, I'm going to hand it over to Leanne.
So one of the things that you might think about when you're going through the divorce process is your existing estate planning documents. And your thought might be that I'm going to update my estate plan after I get divorced, and after my divorce is finalized. And that may make sense, but I wanted to walk through sort of what happens, how your existing estate plan documents apply during the divorce process. Because you may want to update them during the divorce plan or during the divorce process. So if you have an existing estate plan, your documents most likely name your soon-to-be ex-spouse in a number of important roles. They're probably a fiduciary in your financial power of attorney, meaning they can make financial decisions for you. They're probably your decision maker in a healthcare directive. And they're often also named as your personal representative or trustee. So they can have a lot of responsibility. They also may be named, or most likely are named as a significant beneficiary of your will or your trust. They're probably also the beneficiary on your retirement and life insurance accounts in the event that you pass away, or you may own a lot of assets jointly as well. Generally speaking, having the fact that you have initiated a divorce process doesn't change any of that. The one exception, at least in the states where I practice, is that in Maryland, filing for divorce does negate your spouse who is named as your agent in the financial power of attorney. But elsewhere, if you are to pass away or become incapacitated during the process, your named spouse would still be serving in these roles, and they still would be the recipient of whatever you put them as a beneficiary on. So if you don't want that to be the result, then it is worth looking at things and consulting with an estate and trust attorney. Thanks. And so even if you don't have an estate plan, each state does also have what's called intestacy laws. And these are the laws that control when somebody passes away without a will. And generally, I've never seen where this is not the case. They leave a large share of an estate to a surviving spouse. In most states, it would be half or more of an estate goes to the surviving spouse. And as far as I have seen, and in the states where I practice, the laws do not distinguish between a surviving spouse who was in the divorce process and a surviving spouse who was not in the divorce process. So that's just something to think about too if you don't have an existing will. And many states also have something called an elective share. The elective share is kind of similar to the intestacy laws, where it's a law that the state has that gives certain rights to your spouse who survives you. It's a little different though, because the elective share would apply if you have an estate plan and try to disinherit your spouse. So if you were listening a couple slides ago and you say, oh, Leanne said that my spouse would still be the recipient under my will if I died during the divorce process if I didn't change it. Well, then you go change your will and you try to disinherit your spouse. Well, if you were to pass away before your divorce is finalized, the law actually says you can't do that unless your spouse waives their rights. So that's just something to consider as well. There is an elective share, and in Maryland, it leaves a surviving spouse, whether they're in the divorce process or not, 1/2 to 1/3 of a deceased spouse's estate. But these rights can be waived in writing at any point. So if you're going through the divorce process and you and your spouse are somewhat on the same page about things. You know, you each decide that you don't want each other to be beneficiary anymore, and you would maybe want it to go to your kids or somebody else. You can update your documents, and you can have you and your spouse can both waive the elective shares, so that if something were to happen before things are finalized, things will work out how you want, and the spouse that you don't want to be married to anymore will not be the recipient of your assets.
All right, so this is extremely important from my perspective because you're dealing with a sea of issues during your divorce. Okay, as some of you know that are going through a divorce or have just gone through a divorce, you're dealing with custody. Other times it's finances. It's your life. It's basically your entire life, and that creates a lot of complexity. And it basically creates a circumstance where it's a moving target because things change every day. Your spending patterns may change, your financial account balances change, your relationship with your kids change. And I often analogize it to other legal cases. So, for example, if someone gets their foot run over by an SUV, they can sue the driver of the SUV, and the facts really don't change in that case. But in a divorce, the facts are constantly evolving and changing, which makes divorce particularly complex, particularly exhausting, and it's also, of course, emotionally exhausting because, as I said, it's your life. But just because it's tiring does not mean you can let things slip. You cannot let things slip in divorce, and I'm going to talk through a few things that some folks may overlook. So, if you're going to receive a lump sum payment from your spouse as part of the divorce, don't assume that that payment's going to be tax-free. Your spouse needs to get that cash from somewhere. Do they have it on hand? Will they need to sell assets to make that payment? If so, who is on the hook for the tax consequences of the sale? Understand the full picture, not just the amount you're getting, but how it is being paid. Be mindful also in terms of how taxes play into asset division. So if you're trading a tax deferred retirement account for a taxable brokerage account, those assets may not be apples to apples. One will be taxed when you withdraw from it. The other may trigger capital gains on how it's invested. It's also common for people to feel emotionally attached to a marital business or a particular investment. Sometimes people think a particular investment or a business are going to be worth a lot someday, or maybe it's worth a lot already and you're just really attached to it and want to keep it. But if you're planning on keeping the asset until it's sold, you're taking on some risk because, of course, any business could fail. It could end up underperforming, and the investment may not grow the way you think. So future value, of course, is never guaranteed, and it's worth keeping that in mind in terms of your risk matrix. The bottom line, of course, is that divorce is extremely complicated. And you should never feel guilty for feeling overwhelmed or exhausted or whatever you're feeling in that moment during your divorce. And even after your divorce, it takes a long time to recover just to reach normal stasis again. But every case is different and every situation carries its own set of risks. So try to stay sharp and make sure your team is doing the same. So I think a lot of folks have been nervous recently because of the volatility we've been experiencing in the financial markets. There are wild swings going on every day. Today, earlier, I haven't looked recently, but today is even another wild swing day. So we're aware of that, and we wanted to address different types of risk that we discuss with people as financial advisors, and these are very specific financial risks that people deal with, particularly in the context of divorce. There are two types of risks that I wanted to address. One is liquidity risk. And this is typically when someone doesn't have access to enough cash to cover essential expenses, like during the divorce process. You may not have access to cash, for example, to pay attorney fees. Perhaps your spouse has cut off your access to that cash, right? You may not have access to cash to pay fixed expenses. Fixed expenses are expenses that happen every month, like mortgage payments. So liquidity risk is something we encounter all the time in divorce. And then second, business risk. We see this a lot where one spouse is working for a business that is quite successful, perhaps, and they receive some restricted stock units, which may be vested or unvested. And if they're vested, they may not want to sell those restricted stock units. So there's a lot of the entire marital asset base invested in that one business. And that exposes you to a lot of risk because, as I said on the last slide, if that business fails, it could create negative circumstances for you moving forward in terms of being able to maintain your lifestyle. So failure to diversify that business risk can become an issue. Margo, you want to talk a little bit about systemic risk, which plays more into what we've seen in the markets lately?
Sure. So, as John so aptly stated, I know that the market is causing stress for a lot of people right now. So, we are all no strangers to systemic risk, which is the risk that's exposed just being invested in the general market. And this has to do with purchasing power risk, which John is going to talk about in more detail in a bit, which is that the cost of things generally rises. So, over a long period of time, what we can do with $1 becomes different. But one of the things that I wanted to address specifically today is related to the appropriate level of risk for a married couple versus an individual. So when we're married, we may or may not be more aggressively invested, particularly if we're younger, because we're still earning, right? And we're using our earnings to support our daily expenses. So we can afford to be more aggressively exposed to the market because we may not be able to, or we may not need to access those investments in the short term. However, once we get divorced, our cash flow usually changes. Our circumstances usually change. So what may have been an appropriate investment portfolio for you as a married person may not be appropriate for you as a single person moving forward. So one of the things we try to manage for clients is that as soon as we are able post-divorce, getting them into a more appropriately invested portfolio is really critically important for the long-term success of their financial plan, and analyzing how they're going to access their various investments so that we can do so appropriately for them really mitigates that long-term risk.
So this is something that comes up a lot in financial discussions, the time value of money. I find this concept very confusing, but it is critical for people who are going through their divorce and post-divorce to understand the time value of money. I am a visual learner, so I prefer charts. So we have a chart in front of us now. And just to explain a little bit about the time value of money, you want to be able to maintain your standard of living moving forward post-divorce. Inflation, which we've heard a lot about in recent years, can create a circumstance where you're not able to buy the same amount of goods and services with the same amount of money, particularly if you're not investing that money appropriately. And some context about inflation. We expect to have inflation in a healthy economy. In recent years, it's been at a higher pace, so you've seen prices go up more quickly, but generally prices are going to go up in a healthy economy. And that's been the case, for over the last 5 to 6 decades and more. So it's something everyone living, particularly from existing assets, needs to deal with to maintain their lifestyle. So I wanted to just give this example on this chart. So this is a $2 million settlement. So say somebody receives a cash settlement of $2 million in their divorce. If that money is just placed into a checking account and is not placed into an interest-bearing savings account or otherwise invested, the amount of goods and services you're able to buy with that 2 million decreases over time. So for example, with 2% inflation, I'm all the way on the left-hand column here in 2035 and 2%. With 2% inflation in 2035 dollars, that 2 million is 1.6 million. And then if we have more extreme inflation by 40 years from now, which I'm all the way in the bottom right-hand corner of this chart, if so, 40 years from now, it would only buy $416,578 worth of goods and services at 4% inflation. So it can have very extreme effects on your ability to maintain your standard of living if you are not receiving the right advice. And a lot of people, want to just put their money into a checking account because they feel safe in a checking account. But that may not be the best decision for you, and it's why it's important to consult professionals post-divorce to make sure you're in the best possible situation.
So, what are some questions that you can ask financial advisors that may be supporting you through and post the divorce process? So, one of the important questions to ask is, do you specialize in working with individuals going through the divorce process? And what are your associated certifications? This is really critically important, particularly if they're supporting you through the divorce process, because we want the financial advisor to understand the divorce so that they are actually helping your attorney instead of hindering the process. And then the certifications are important because that individual needs some training to be able to have the context of family law so that they can also help you execute the necessary things post-divorce. The second important question is to inquire as to how they're compensated. So some financial professionals sell things like mutual funds, insurance products, or they represent some sort of bank or wirehouse. And in that regard, if they give you certain type of advice during and post-divorce regarding purchasing certain things, you just want to understand what the potential motivation may be behind that. Are they suggesting you do something because it's in your best interest, or are they suggesting it because of their compensation structure? And there are professionals that do not sell any products at all, and for a myriad of reasons, you may want to consider this, particularly during the divorce process. The other thing is, how do you handle your projections? Are you incorporating inflation, as John just talked about, taxes and other cost adjustments, which we're going to get into further detail about in your projections? Because we want to make sure that we understand all the inputs and how they influence the outputs for you for those projections. Because if you're basing decisions on that, you want to make sure that you have a full understanding about how that financial professional got there. And then how often are they planning to meet with you? Are they going to be accessible for you in between meetings? This is really, really important during and immediately post-divorce because things need to happen in a timely manner, and you can't always just plan for it on a monthly or quarterly basis. And then this final question is just a personal thing for me, but checking to make sure that the way that they're working with you is not in an arrogant or condescending way. So I like to ask a financial professional to explain a complex financial concept because it's really important during and post the divorce process that you are informed and empowered to make your own choices, not made to feel like you have to rely on a financial professional to explain something to you because they don't think that you're smart enough to understand it yourself. So things can get very complex very quickly in the divorce process. And so there are complexities regarding trust and divorce. Leanne, can you talk a little bit about that?
I can, but also we have 4 questions in the Q&A box. Um, we want to take a quick pause to answer some of them?
Sure.
Oh,
Yeah,
okay.
I have to apologize. I didn't see the Q&A box. I saw the chat. Apologies. Go ahead.
There's both. So I can read them off. The first one, in the state of Virginia, how helpful is it to have a prenup and put everything related to complications in there prior to the marriage? How much can you put into the prenup? When is the best time to get one in place? Um, John, I don't know if this is better for you to answer than me. I can.
I'm hesitant to answer it because I am not barred in the state of Virginia or
And
familiar with the laws there. So
okay, I'm not either. But we can answer, I think, generally.
Mhm.
Um, you can put a lot into a prenup, and a prenup is a great place to sort out before things get sticky and messy, how you want things to go based on your current situation. And prenups can't be egregiously unfair. So there are limitations on exactly what it can say. Generally they require full financial disclosures in order to be valid. And as a general rule, you cannot force your spouse to sign one under duress. So you waiting till the week before your marriage to hand it to them and demand that they sign it, or they'll calling the wedding off, that probably won't fly. So it's something you want to bring up earlier rather than later. But they are a great idea. Do you have anything to add to that, John?
Yeah, so I'll just say most attorneys are not going, the best attorneys are probably not taking your case if you wait until too late before your marriage to start the prenuptial agreement process. So give it enough time because it actually can be a longer discussion than you think because you're dependent on other people's schedules, like the 2 attorneys that might be negotiating it. And there are emotional complexities associated with prenups. I'll also say when I speak to people about prenups, I often say that it is a great family planning exercise. I think a lot of it's taboo for some people because, you know, they're concerned about it predicting the end of their marriage before it begins. But in reality, it's a great way to have difficult conversations before you're married, which helps avoid conflict down the road.
Okay, hopefully that answers. Next question, with an investment account, when dividing assets simply, example 50-50, do the capital gains or losses go with each resulting account proportionately?
Go ahead,
It
John.
it depends on how the marital settlement agreement is written. I'm sorry for the lawyerly "it depends" answer, but it does depend on how the marital settlement agreement is written. Generally, if the account's being divided in kind, or pro rata, typically the answer to that question would be yes. But again, it depends on the individual circumstances of your case.
All right. Thanks, John. Next question. I currently don't have a trust, will, power of attorney. I have a young child involved and I've had intentions of establishing a will at minimum. Is there a way to move forward in completing these without my spouse being included? Does it make sense to wait for a divorce? Divorce has been put on pause for a number of reasons, likely to occur within the next 12 months or so. So I would say that yes, it's certainly possible to prepare estate planning documents without involving your current spouse, but you do need to be mindful of what I brought up before, which is the spouse's elective share rights. And again, just to reiterate, what that means is that if you leave your spouse out of the will, then they have the ability, if you pass away while still married, they do have the ability to go to court and claim a part of your estate. So that's a consideration to be mindful of. But I, if you have a young child, I definitely do recommend putting something in place. Just, I mean, hopefully nothing unfortunate happens, but just to protect your child and make sure that they have the financial support and care they need if something were to happen to you.
Sure. So
Go ahead.
yeah, so there's one in here saying that I didn't use the word fiduciary in discussing financial advisors, but as we understand it, that's the word to look for. And Robert, you are correct. Fiduciary is a hot button word right now that is used to describe a financial professional who puts the interests of their clients first. The only caution that I will have here, and the reason I didn't use the word earlier, is because some professionals will use this word in their marketing materials, but they still represent products or sell insurance or work with a bank. So that word alone isn't necessarily enough of an indicator, in my personal opinion. You still want to ask some questions about the compensation structure so that you can make a choice for yourself about the type of advisor you want to work with.
All right. I think that we're through our questions now. So I'm going to talk about trusts for a couple minutes. So the main purpose of this conversation is that if there is a trust involved if you have a trust or a beneficiary of a trust or trustee of a trust or your spouses, that it's very important that the attorney who's handling your divorce understands it or brings in an attorney to support who does. So sort of basic trust structure and trust lingo. Every trust that exists involves 3 different parties. The parties are the trustee. This is the person who manages and controls the trust, who is the purse strings. Basically, there's a grantor. That's the person, the word settler is sometimes used as well, but grantor is the person who created the trust or contributed to it, put the money or whatever is in the trust into the trust. And then there's the beneficiary, who's the lucky one who is entitled to the benefits from the trust. So when and beneficiaries' interest in trusts can vary widely. They might have a withdrawal right, meaning they can take everything out of the trust, or they can take 1/3 of the assets out of the trust. They might have a mandatory income or principal distribution, meaning one of the types of trusts that we talk about commonly that John referenced earlier is called a Q-tip trust. And in that trust, the beneficiary, who's the spouse, has the right to receive all of the income from the trust. And other trusts might be set up. Parents often will set up a trust for a child where the child might receive 1/3 of the balance of the trust when the child turns 25 or 30 or something like that. So there's components like that that give a beneficiary a very tangible right into a trust asset. On the other hand, distribution rights might be fully discretionary, meaning it's totally up to the trustee whether or not they are going to give anything to the beneficiary. And they also might have something called a lifetime or a testamentary power of appointment, which is basically a power to direct where the trust assets go or to give them to somebody else. And these rights are very crucial to how a trust would be looked at in the event of a divorce. Thank you, John. Okay. And then on the other side of things, a trust can be either revocable or it can be irrevocable. A revocable trust is a trust that a grantor creates, and they have the right to change it or to revoke it or to pull assets in and out during their lifetime. This type of trust is essentially disregarded as being separate from the person who created it. So if there's a revocable trust involved, it's, like I said, it's looked through. It wouldn't be treated any differently than if the assets were held by an individual themselves. On the other hand of things, there is an irrevocable trust. This type of trust cannot be changed without extreme difficulty. And generally, it can't be changed by the person who wrote it. So if the spouse is only a grantor or a trustee of an irrevocable trust, the assets inside the trust would generally not be considered to be his or hers, absent some kind of fraudulent transfer or something very fishy going on. And then if the spouse is a beneficiary of a trust, there are a number of different things that impact how their interest would be looked at. First is that state law, every state has a law that will address whether a creditor could reach that beneficiary's interest in a trust. Generally speaking, if a beneficiary's interest is fully discretionary, that beneficiary doesn't have any property rights into that trust. Versus if they have a mandatory distribution, like we talked about just a moment ago, that beneficiary is considered to have property rights in that trust. And that analysis can be rather complicated depending on the wording of the trust. A couple other notes is that if a trust, even if a spouse wasn't written in a trust as a beneficiary, if the trust is used improperly for his or her benefit, then the spouse might have a claim against the assets in the trust outside of what would normally apply based on the technical wording of the trust. And Maryland courts in the year 2000 took a look at a spouse's right in an irrevocable trust in a case called Kakamisi. I'm not sure if I'm saying that right. Kakamisi versus Kakamisi. And that case involved an ILIT, which is an irrevocable life insurance trust. It was a trust that was created by the husband for the benefit of the wife. And the crucial component of that case is that the trust had wording in it that gave the spouse $5,000 a year as a mandatory distribution. And so when the court looked at that case, they noted that because she had this mandatory distribution, that the assets in the trust are a marital property of the wife. And then ultimately the court ended up not making a decision about how to value that interest in the trust. And this was an appeal, and they backed it back down to the trial court to make that determination about how to value that $5,000 a year interest based on the facts of the case. And in that case as well, the court did note that, and they cited to a North Dakota case, that where the receipt of future benefits from a trust is too speculative, then the potential benefits are not valued as assets in the marital estate. And that really lines up with sort of the trust law in different states that relates to creditors' rights in trust assets. which again, generally, if the beneficiary's interest is tied to a particularly discretionary standard and the trustee has a lot of control and the beneficiary doesn't have control, then the assets in the trust probably would not be considered to be either have value or to be considered a marital asset.
Leanne, Leanne, excuse me 1 second. There is a question I think that's related to this in the question and answer right now. Somebody posted, I am one of the trustees of a trust. This trust is not mentioned in my draft marital settlement agreement because I do not receive anything of value related to this trust now, but may in the future. Is it imperative that it be described or listed in the marital settlement agreement, even if nothing of value would be received until far into the future?
So I don't know the answer to that. Does your attorney know the answer to, or does your attorney know about the interest in the trust? I would say generally, probably an interest in a trust that is just in the capacity as a trustee, but not as a beneficiary, may not need to go into the settlement agreement. But I would think that if you have an interest in the trust in the future, your attorney needs to know about it and make an assessment. And I think it probably would also depend on the terms of the trust and, how your interest is defined in terms of whether or not there's any value.
Yeah, I would say it's critical that you inform your attorney of the trust. And they can make the judgment as to, based on the facts and circumstances of what's in the trust, can make a determination as to whether it belongs in there. But everything,
Mhm.
this is a key thing during your divorce. Please disclose your assets. People can get into trouble not disclosing things. Disclose things so they don't become problems later. Leanne, are you good with this slide? Yeah.
I am, yes.
So we've been talking a lot about all the things that go into the considerations of the agreement between you and your spouse and talking about the things to look for in the future. But we wanted to just stop and make a comment here to make sure that before you settle your divorce, make sure you're developing a clear vision for your next chapter. It's very hard to make decisions about what you need or want or talk to your attorney about what you'd prefer they advocate for you if you don't have a clear idea of, financially speaking, what your next chapter is going to look like. So one of the ways in which we develop this vision is we do projections. Very commonly, projections in the financial world are done as a Monte Carlo projection. So what this means is that essentially you run a number of potential outcomes, actually specifically 1,000 of them. And what it develops is sometimes what looks like a spaghetti report. This is literally a report that looks like a bunch of spaghetti is across the front of it. And each spaghetti string represents a potential outcome, whether it be positive or negative. And then they take all of that information and they come up with like, what's the best potential case, what's the average case, and what's the worst case scenario of all those different scenarios that could be. And we look at various inputs, right? What kind of compensation might I be receiving? What are my cash inflows? What inflation rates are we assuming? What assets are we able to draw from? And then we look at the potential of the market performance over a period of time and how that may turn out for you. Generally speaking, the best case scenario rarely occurs, right? So we don't focus very much on that best case scenario because that best case scenario sometimes gives us false hope about how it might turn out. We really want to look more at the average case scenario and then have a discussion about the potential worst case scenario. So there we go. Thank you. So the average case scenario is the one we spend the most time on. But the worst case scenario is something we do need to discuss because we want to make sure that you have a clear picture of what could this really look like if perhaps the market doesn't perform well over a period of time. What choices might I need to make and how might I influence this outcome? And then what are the specifics associated with the different things that I can advocate for that may positively influence this outcome?
So when we're working with Monte Carlo projections, a lot of people often make the mistake of thinking that the Monte Carlo is a crystal ball. It'll project your potential outcomes until your probable date of death, right? Which could be 30 years out for people. And some of our clients and some people who we work with generally can mistake that initially for being a crystal ball but it is not in fact a crystal ball. It's really a decision maker for you. It's a tool that you can use to make an informed decision. So for example, if you're in the middle of settlement negotiations, how does this scenario look as opposed to scenario two? Or post-divorce, if you're looking to buy a house and stop renting, how does that impact your financial circumstance? So it helps you make decisions about big moments of change in your life and also to make incremental changes. We meet with clients quarterly generally and more if necessary. But in those quarterly meetings, we talk to them about their spending. We talk to them about their asset level, if there are changes in their projections, how to manage for those things. So it's just important to just think through what the purpose of the Monte Carlo is and don't stress about it as, for example, a crystal ball or look to it as some beacon of hope, because that's not really the purpose. So Margot, can you talk about some of the questions people should be asking their financial advisor and putting together the Monte Carlo?
Sure. So I'm going to just breeze through this, John, because we're running out of time here, I think. But just a couple comments that I'll make is just make sure that you're asking how the spend down of your assets is being calculated. How are they calculating the taxes? Are they taking into account your new tax circumstance? Are they taking into account your age and how you can access certain accounts without paying a penalty? And then how are we looking at any real estate transitions that are necessary and what sort of exposure to the market are we assuming? So I think if you have a lot of questions about this, we should certainly have a follow-up discussion about your personal situation because this is a critically important topic, but I don't want to spend too much time on it before we head into the post-divorce checklist items. So one of the things that we said that we would talk about today, which is critically important, are what are the things that we really need to consider after that divorce has been finalized, right? And this is a moment where we may be feeling stressed, right? We're kind of relieved. We're like, I don't want to deal with this anymore. But believe us when we tell you, you really do need to deal with some items. And we're going to go through a few of them. So from the financial standpoint, your beneficiaries, you really need to make sure that your beneficiaries are appropriately articulated and enforced per the settlement agreement that you've signed. We don't want you to pass away and have your money be transferred in a way that you did not intend. Also, getting those mortgage refinances and assumptions done. We're going to talk a little bit more about refinance versus assumption in a little bit, but just know that we want you to comply with the terms of that agreement, and we want to make sure that it's done as quickly and efficiently as possible, costing you the least amount of money. Making sure that whatever transfers need to happen for the retirement plans actually get done. John's going to talk about a quadro qualified domestic relations order, but they can get very complex. And so you should ask for help for sure in doing that, setting up the right accounts and making sure that the transfer doesn't incur you taxes as well. Health insurance is oftentimes a scary thing for people to manage if they haven't done it on their own before. Definitely ask for help getting that done. You'll want to make sure you understand how much is coming out of pocket for you and how that may impact your cash flow. And then just launching your next chapter in a way where your financial planning and investment management is appropriately deployed for your new situation.
So in terms of the legal steps post-divorce, make sure titles are changed. If you are taking on the ownership of the marital home, you want to make sure that your ex-spouse is removed from the title in accordance with the timeline in the marital settlement agreement. Marital settlement agreement or the judgment of divorce, if you've tried your case, will often have very specific timelines you need to follow. You need to be making sure you're on top of those timelines with respect to titles, transfers, could be anything from, your financial accounts to when you're going to pick up furniture from the other person. So just keep an eye on what those deadlines are. As Margot said, the qualified domestic relations order, if you have an employer-sponsored retirement plan in particular, keep an eye on this. It will need to be drafted by your attorney or someone they've outsourced the drafting to, and then submitted to the plan administrator. The plan administrator submitted to a judge. The judge has to sign it, and then it is submitted to the plan administrator, who then has to approve it. So it goes through a long process, and you have to stay on top of that. And then updating wills and estate plans, and I'll let Leanne touch on some key aspects of post-divorce estate planning. But first, I'm going to mention how we view our financial planning, or how we view the post-divorce lifestyle and our conversations about financial planning. And we often view it as a series of choices. So the bottom line is that in your next chapter, you're going to finally be in the driver's seat. Okay. So for the whole divorce, you've been on other people's timelines, the divorce lawyer's timeline, your spouse's lawyer's timeline, your spouse's timeline. And at some point, it gets exhausting and taxing, both emotionally and monetarily. But once the judgment of absolute divorce is issued, you regain your power. And you need to really enjoy that, and take the power back and have some choices in your life. But during the divorce, you want to position yourself such that you have more choices to make in your next chapter. After the divorce, you're going to seek out a new balance. It's going to include employment, housing, budgetary, and emotional choices, and you need to get the right advice. So that's from financial counsel to estate planning counsel. So I'm going to send it over to Leanne to talk about post-divorce estate planning.
Okay. So again, I'm kind of going to go through this somewhat quickly because we are running out of time, but we wanted to touch on the impact that divorce has on your existing estate planning documents. And the bottom line really is that if you get divorced, you need to update your estate planning documents. Depending on where you live, portions of the document may or may not be revoked based as a result of the divorce. So in Maryland, for example, if you had a will and you left everything to your spouse, and then if your spouse was deceased, you leave things in trust for your children, the portions relating to your spouse would be revoked and then things would go to your children. DC, on the other hand, if you had a will and you got revoked or you got divorced, the whole will is revoked, which is kind of an interesting result. And then there's some documents where the divorce doesn't have any impact on this validity of the estate planning documents and the mentions and the bequest to your spouse therein. But you may have documents that you have prepared with the assistance of an attorney that have a different result than what the Maryland and DC statutes say, because they may, within the existing documents, say that if you divorce your spouse, your documents, like they're treated as having predeceased you. But in any event, the best thing to do is meet with an estate and trust attorney and go through your current situation and have documents prepared that fit your current life, your current family, and your current goals. And we wanted to talk a little bit about sort of, marital settlement agreements, as we've been discussing, have timelines in them. They have stipulations about what the different parties are required to do. And this is straight out of a case that my firm handled, because the client the husband and wife divorced, and there are certain things that were required to be done under the settlement agreement, and they were not done. And this is just meant to illustrate what happens when the terms of the settlement agreement are not followed and how messy things can actually become. Basically, the wife was required to maintain an insurance policy for the benefit of the husband until children turned 30. She was also required within 3 years of the divorce, like John said, there's a strict timeline to refinance her home and take the husband off of the existing mortgage, and then the husband was required to convey his interest in the home to her. Well, she didn't do either of those things. She ended up maintaining a life insurance policy, but she changed the beneficiary to her mother, and then she never refinanced her house, and she never took her husband off the deed, and then she died. And as a result of that, the husband had to hire an attorney to deal with the life insurance because there's $600,000 of benefits that were supposed to go to him. The insurance company had to do an interpleader action in the court to basically be directed what they're supposed to do with the money, because usually they would just pay it out to the beneficiary, but obviously it was supposed to have gone to the husband under the settlement agreement. Ultimately, the interpleader action was successful, and the husband got the funds. And then in terms of what happened with the house, it's actually still ongoing and it's become very messy. The home ownership. So if you own property as tenants by the entirety with your spouse, and then you get divorced, your ownership interest converts into tenants in common. That means each of you owns half, and your half of the home goes under either the terms of your will or the intestacy laws if you don't have one. So husband ended up owning half of the house, even though he was supposed to be taken off of it under the settlement agreement. And then the wife, her half of the house is in the estate. They ended up selling the house, and the wife's estate and the husband are now involved in ongoing very costly litigation about what's supposed to happen with the money that came in from the sale of a house. So that's just a little lesson about how messy things can become when the terms of settlement agreements are not followed through. It is very important to, if you have a settlement agreement, to do what it says, and not doing so can end up costing your family and your ultimate beneficiaries a lot. And one of the lessons that we learned from that example relates to life insurance. So in the settlement agreement in this case, and as is often the case, the person who was insured was the owner of the life insurance on his or her own life. And the person who is insured, who owns the policy, is the one who can control who the beneficiary is. So just something to look into to sort of increase the amount of control over that you would have over the funds that you are supposed to be the beneficiary of under your settlement agreement and after your divorce. Life insurance doesn't actually need to be owned by the insured person. So husband could have, assuming that health and other things didn't prevent this, husband could have taken out an insurance policy on the life of the wife and then been in control of the beneficiary of that. And that would have avoided the insurance issue. So that's just something to be mindful of, that you can be the beneficiary and the owner of insurance on somebody else's life. And where significant value is involved, it's a good idea to think about life insurance trusts to keep the proceeds out of somebody's estate for tax purposes.
Yeah, and to another point, Leanne, you can actually transfer ownership. So if you have existing life insurance policies, you can transfer ownership to the other party. We also just want to mention before people hop off something very important, which is that as of yesterday, their Maryland governor signed into law a new law related to mortgage assumptions and divorce. We had the honor of being able to testify when these bills were heard before, before our leadership. And yesterday they signed it in force, which is to say that if you are going through a divorce, a mortgage company must be able to consider you for an assumption instead of a refinance. And it doesn't mean that they have to qualify you for it, but they have to consider you for it. And so this means if you currently have a low interest rate mortgage on your home, and in your divorce, you're the one who keeps the home, instead of having to refinance to a higher rate, you can actually assume the mortgage as is with the low interest rate and continue on with those payments. And this is really critical for people who need to keep that payment low in order to stay in their marital home. So please just take a look at this. It literally was signed into law yesterday. It's an important move for those of us in Maryland, for individuals who are getting divorced.
It's effective the 1st of October, I think, Margot.
That's right.
If you're working with a mortgage professional in your divorce, I strongly suggest you have them look at this to see if you will be able to qualify under this law. If you're not working with a mortgage professional in your divorce and you are going to have a refinance or assumption issue, please call a mortgage professional because they're very useful. Lastly, before we finish up, just building on what Leanne said, it is crucial to do what the marital settlement agreement says. No, I will do this later. I'm tired from the divorce. There is no rest for the weary in this situation. You have to keep pressing forward, or you could end up in a very difficult circumstance, 2 to 3 years in the future. Don't assume account transfers are going to happen automatically. Get them done. Remember, your marital settlement agreement is subject to a court order. And as a result, the consequences with not following a court order are in place if you do not follow through. failure to change your various accounts to what they're supposed to be under the agreement, not obtaining documentation on the life insurance policy, request documentation of the life insurance policy if you are not the owner and you are entitled to it under the agreement. A lot of settlement agreements will say, if this person is not an owner of the life insurance policy, they are entitled to request a copy of it to ensure they're the beneficiary of the policy, and they're entitled to get it within 30 days of the request. So make sure you make that request if you're entitled to do so. And do not ditch your advisors and attorneys because you're exhausted from the process. Follow through, follow through, follow through. All right. We can probably answer questions now.
All right, I can pull up the existing questions and go through them. I just want to say thank you to everybody who joined us today. We appreciate your attendance. We hope you got something out of the program, and you can see our emails and our contact information below. I think we're planning to send out a copy of the slides to those who attended. So you'll have our contact information there, but you are, of course, welcome to reach out to any of us. Okay. First question. And anybody who doesn't want to listen to questions, you're welcome to hop off. But first question is, let's say your house has the name on home, but the land is owned by the estate and trust. How would that play out in court, even with a prenup? What is she or he entitled to in terms of other assets? I am having a little bit of a hard time breaking down the details of that question. Sounds like if the land is owned by a trust, then the house probably is as well, because they are not separately deeded interests, generally speaking. And if there was a prenup, the prenup probably would have addressed what happens in with respect to the trust. Probably would have said that the other spouse doesn't have any rights or interest in them. But I don't know, which would totally depend on what the prenup said and what the trust said, how everything was used, and what he or she is entitled to in terms of other assets. I think that would really be a question for the divorce attorney.
Yeah, I concur. It depends on more. We would need more facts to answer the question.
Yeah, sorry, I know that's a little bit vague, but we answered the best we can. A question about the recording. I actually don't know if this is going to be recorded, or I know it is recorded, but I don't know if the recording is being shared, and I would have to get back to you about that. So if you're interested in a copy of the recording, shoot me an email and I will see if I can get that to you. Okay, another question. If mortgage assumption via refinance is important, it could be wise to delay the divorce until October 25.
I see the question there. So the question is born from the fact that this law goes into effect for any divorces that happen in October 2025 or later. So if you're divorced October 2025 or later, that assumption law is retroactive for existing mortgages. And I think that the answer to the question is two-part. The first is if you're able to call your current mortgage holder and determine if your mortgage is currently assumable and what the process is associated with that or that assumption, you may not need to wait to have this law apply to you. But if you call your mortgage company and determine that they do not feel that this loan is otherwise assumable under the current rules, and or they don't allow assumptions, which some mortgage companies decide for themselves prior to this law going into effect in Maryland, then you may want to talk to your attorney about the financial implications associated with not finalizing the divorce before October.
As is the case with all new legislation and statutes, it may take some time for companies to respond to this. And it also may take some time for attorneys and mortgage professionals to get their arms around it. So you can reference it. I mean, it's Senate Bill 689 in Maryland, House Bill 1018 in Maryland that just passed this year. You can look it up online and send it over to the folks you're working with to get answers based on their perspective, and they'll be the best people to give you answers based on your specific circumstances.
All right, and then there is one last question, it looks like in the chat box. Would a refinance or assumption be needed if the receiving spouse is the only spouse on the note, but the conveying spouse is on the mortgage and not the associated note?
So if you are the only individual that's on the debt, on the note, in this circumstance, you do not need to reassume your own debt. So as long as you get a quit claim deed, which means the spouse that you're removing basically conveys the deed over to you in its entirety, you would want to give that to the mortgage company so that they have it, but you are already personally assuming that note in this circumstance.
Looks like we have a couple more questions that are coming in the Q&A. So I think this is back to the question about a land and a home. Can't the land be bought before you buy a home, build a home, correct? Example, you buy land this year, but build 2 years later. Yes, that is true. Generally, the ownership of real estate, though, and structures on top of land is it is titled in a deed. So your deed, the deed to the land that was purchased will generally say that the deeded owner of the land owns the land and they own any structures on top of it. So there's not a separate title to a house that is on top of land, if that makes sense. Next question is there going to be any offered seminar or conversations to go over steps in the divorce process and offerings of service from Frost? Sorry, I logged in late, had technical issues. So Frost, we do not service divorce in terms of representing you as your family law attorney. And I'm an estate and trust attorney, and I'm happy to we offer services on the estate planning side of things. So wills, trust, financial powers of attorney, medical directives. But we don't actually offer divorce services. If you're in need of some, one of us can certainly refer you to a family law attorney.
Yep.
Margaret, do you want to talk about Divorce 101?
Sure. Yeah. So there's a service that's offered called Divorce 101. I can forward to anyone if they want to send me an email. It's for individuals who are looking for more information about the divorce process. And there's a multi-step sort of series of seminars where divorce attorneys and mental health professionals and financial professionals give information in a group setting. Also, we certainly can give a list of potential divorce attorneys for anyone that's looking for them. Somebody had asked a question about Florida. We have relationships all throughout the entire United States. So as Leanne stated, if any of us can refer you to somebody that may be able to help you, we'd be happy to do so.
Great. Well, I think that is it for our questions in the chat and the Q&A. If anybody has any after we sign off, feel free to reach out to one of the three of us, and we will do our best to answer.
Thank you, everybody.
Yeah,
Thank
thank you
you.
again for joining.
Okay, bye.